Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in. Welcome to the show, everyone. Let's jump straight into it. I want to start with a date that every lawyer in Australia needs to mark in thick red ink on their calendar. July 1st, 2026.
July 1, 2026. That is the exact day the regulatory ground shifts beneath the Australian legal profession. We are talking about the official start of Tranche 2 of the AML CTF Act. Lawyers are no longer just advisors. They are officially being drafted onto the front lines as gatekeepers against financial crime.
Exactly. The Financial Action Task Force has pointed out for years that Australia had this massive regulatory gap. Criminals aren't just walking into banks with bags of cash anymore. They're using professional service providers, lawyers, accountants, conveyancers, to set up complex structures, buy property, and essentially wash dirty money through legitimate channels. And law enforcement has seen too many lawyers acting as unwitting facilitators.
Unwitting is the key word there. A lawyer might genuinely believe they are simply handling routine commercial work for a long-standing client, drafting documents, facilitating a transaction, or moving funds in the ordinary course. But under this new regime, that assumption is no longer enough. The legislation places a proactive obligation on practitioners to identify whether they are providing a designated service and whether there is a money laundering or terrorism financing risk attached to the transaction. In other words, not knowing is no longer a shield. A lack of awareness or even a genuine misunderstanding of the rules will not excuse non-compliance. The expectation now is that firms actively understand the risks sitting inside their own practice areas. And if you do get this wrong, the consequences are absolutely eye-watering. We are talking civil penalties of up to 100,000 penalty units for corporations. At today's rates, that translates to approximately $31.3 million. Even individual practitioners are exposed to penalties of up to $6.26 million. Those numbers are not theoretical scare tactics either. They are designed to force firms to take compliance seriously from day one. For many practices, particularly smaller and mid-tier firms, a penalty on that scale would be financially catastrophic.
$31.3 million. That is enough to wipe out a mid-tier firm overnight, and probably permanently. But honestly, Jack, the financial penalty is only part of the story. The reputational damage could be even worse. If AUSTRAC comes knocking and a firm cannot demonstrate that it has proper systems, risk assessments, and compliance procedures in place, client confidence could evaporate instantly. In the legal profession, trust is everything. Once that trust is damaged, it is incredibly difficult to rebuild. No firm wants to see its name associated with allegations that it facilitated money laundering, organized crime, sanctions evasion, or illicit foreign funds. Even the perception that a practice was used as a conduit for criminal activity could have devastating long-term consequences for referrals, client relationships, and professional standing.
Spot on. And that is why this represents such a profound paradigm shift for the legal profession. Traditionally, many firms have viewed AML and counter-terrorism financing obligations as something that primarily applied to banks, casinos, and financial institutions. But from March 31, 2026, firms providing designated services can begin enrolling with AUSTRAC. And then from July 1, the full compliance regime takes effect. From that point onward, firms will need formal AML CTF programs, documented risk assessments, customer due diligence procedures, ongoing monitoring processes, and systems for suspicious matter reporting. That is a completely different operational framework to what most legal practices are used to. And for smaller firms in particular, this is going to be a huge cultural and administrative adjustment. There is still a misconception floating around that these reforms only target the big end of town, the major national firms doing billion-dollar transactions. But that is simply not the case. A suburban practice handling property matters, business sales, or trust structures can still fall squarely within the regime. In many ways, smaller firms may feel the pressure even more sharply because they often have fewer internal resources, smaller compliance teams, and less experience dealing with regulatory reporting obligations.
So let's get into the weeds of what actually triggers these obligations, because this is where the detail really matters. Importantly, the Act does not regulate every single thing a lawyer does. The regime is targeted specifically at what are called designated services. That means practitioners need to understand exactly where the legislative boundaries sit. Let's start with real estate, because property transactions are one of the clearest and most significant areas captured by the reforms. How does the Act define what falls inside the regime and what stays outside it?
Right, so real estate is now specifically defined under the legislation, and it covers things like the transfer of fee simple interests, leaseholds, and land use entitlements. But the really important thing here is that the Act draws some very deliberate lines to avoid capturing ordinary, low-risk legal work. One of the clearest examples is commercial leasing. Standard commercial leases are excluded from the regime unless the lease term exceeds 30 years, excluding any options for renewal. That distinction is incredibly important for practitioners working in property law because it prevents everyday leasing matters from automatically triggering full AML CTF compliance obligations.
30 years. So your standard 5x5 retail or commercial lease is completely outside the regime. But the moment you move into something like a 99-year ground lease for a major development project, suddenly you are operating inside the AML CTF framework, and all of those compliance obligations kick in.
Exactly. The legislation is really trying to strike a balance there. It keeps routine, high-volume leasing work outside the net while capturing the kinds of long-term, high-value transactions that present a greater money laundering risk. And you see that same risk-based approach reflected in corporate transactions as well. For example, if a lawyer is assisting with the purchase or sale of a business or company interest, there is a strict 25% beneficial ownership threshold built into the regime. If the client is acquiring less than a 25% ownership interest, the designated service is generally not triggered. But once that threshold reaches 25% or more, the lawyer moves squarely into AML CTF territory.
Right, so that 25% threshold becomes absolutely critical in practice. It effectively distinguishes between transactions involving minor passive interests and those involving meaningful ownership or control. Small equity raisings, limited share purchases, or relatively minor investments may stay outside the regime, which avoids unnecessary compliance burdens for lower risk work. But once a transaction gives someone significant influence or control over an entity, the legislation expects lawyers to conduct much deeper scrutiny around beneficial ownership, source of funds, and transaction risk. But what about trust accounts? Because this has been one of the biggest concerns across the profession. A lot of lawyers hear money laundering laws and immediately panic that simply operating a trust account could turn them into a reporting entity overnight.
And this is where the explanatory memorandum provides some very important reassurance. The legislation makes it clear that lawyers are not captured under the AML CTF regime purely because they operate a trust account. There is a specific carve-out under Section 65C for routine administrative or ancillary payments made through trust money. So if a firm is paying a barrister's invoice, transferring money to an expert witness, covering mediation costs, or paying court filing fees, those activities do not trigger designated service obligations. The law recognises that these are ordinary functions of legal practice rather than higher-risk financial activities.
Thank goodness for that. That would have been an absolute administrative nightmare. And what about family law or probate? If a court orders a property transfer as part of a divorce settlement, do those lawyers have to do deep dive client due diligence on their own clients?
No, and this is a really sensible carve-out. Any transfer of real estate or corporate structure that is pursuant to a court or tribunal order is exempt. So court-ordered family law property settlements, probate-related transfers under a grant of probate, or liquidators acting on a court order, they are all safely outside the compliance net. The risk of money laundering in those scenarios is deemed low because a court has already overseen the outcome.
Okay, so if we are in scope, say we're doing a standard commercial property conveyance or setting up a family trust, what actually goes into this compliance shield we have to build?
Well, first up, you must appoint a fit and proper person as your AML CTF compliance officer, or AMLCO. If you're a sole practitioner, congratulations, that's you. Second, you have to develop a documented, risk-based AML CTF program approved by senior management. And here's the kicker, that program must be independently reviewed at least once every 3 years.
3 years. And that reviewer has to be independent, meaning they can be internal, but they can't have been involved in actually building the program. Now, Jack, we have to talk about the elephant in the room, legal professional privilege. LPP is sacred in Australian law. How on earth does a lawyer report a suspicious matter to AUSTRAC without violating their duty of confidentiality to their client?
This is the most delicate part of the entire reform. The amended Act tries to strike a very careful balance. Under Section 242(1), you are explicitly not required to disclose information or documents that you believe are subject to LPP. If you have to withhold information on those grounds, you notify AUSTRAC using a specific LPP form.
Right, but what about suspicious matter reports or SMRs? If the only reason I suspect my client is up to something is based on privileged legal advice, do I still have to file an SMR?
Actually, no. Section 41(2)(a) is a massive relief here. It says you do not have to submit an SMR if your suspicion relies entirely on information protected by LPP. You don't even have to submit the LPP notification form in that specific scenario. But remember, this only applies to genuine legal advice. Pure transaction management or holding funds in escrow, that's generally not privileged.
That is a crucial distinction. We cannot use LPP as a blanket shield for administrative tasks. So, if we're looking at a practical, actionable checklist for a firm starting to prepare right now, what are the immediate steps?
Step 1. Audit your service offerings. Are you doing in-scope work like property transfers, structuring, or managing client money? Step 2. Revamp your onboarding. You need to identify your clients, verify their identities, and screen for politically exposed persons, or PEPs, before you provide the service. Step 3. Put a process in place for suspicious activities. If you spot a red flag, you have a strict 24-hour window to report if it's terrorism financing, or 3 business days for money laundering.
And remember, tipping off is a crime. If you file an SMR, you absolutely cannot let the client know they are being investigated. Look, July 1, 2026 feels like a while away, but building these systems, training staff, and getting your risk profiles sorted takes months. The countdown has officially started.
It absolutely has. Start the conversation inside your practice now, because the cost of being unprepared is simply too high. Thanks for listening, everyone. We'll see you in the next episode.
Catch you next time.
That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD page, linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.